What is the role of international law in restraining military aggression? This question often echoes in the halls of academia, in the courts of justice, and in the council chambers of the United Nations. To unravel this complex issue, we will explore a case study involving South Africa, Israel, and the International Court of Justice, or the ICJ. Why did South Africa approach the ICJ? To answer this, we need to understand one of the ICJ's missions: to enforce international conventions among states. In this case, the convention in question is the one on the prevention and punishment of the crime of genocide, dating back to 1948. Every party to this convention can request its enforcement, as they stand as guarantors of its correct application. This process, however, targets national entities, not individuals. Accusations against individuals fall under the jurisdiction of the International Criminal Court, or the ICC. So why does the complaint focus on the crime of genocide? Because genocide is the crime for which an international convention exists. This is not the case for crimes against humanity or war crimes, which do not have a specific convention. However, the potential judgment of individual perpetrators of these three crimes is entirely possible in parallel at the ICC. What are the differences between the crime of genocide, war crime, and crime against humanity? Here's a brief breakdown. To qualify as a crime of genocide, there must be an intent to destroy in whole or in part a national, ethnic, racial, or religious group. This includes the murder of members of a group causing serious bodily or mental harm, deliberately inflicting conditions of life calculated to bring about its physical destruction, imposing measures intended to prevent births, or forcibly transferring children of the group. On the other hand, a crime against humanity can also be committed with the intention of attacking a population, but it doesn't target a particular group as such. The list of acts that can constitute a crime against humanity is broader. It includes murder, extermination, deportation or forcible transfer, enslavement, imprisonment, sexual violence, torture, persecution of a group, enforced disappearances, the crime of apartheid, and other inhumane acts. For both the crime of genocide and crimes against humanity, there is no necessary link with an ongoing armed conflict. What is judged are certain acts, regardless of the context in which they occur. To wrap up, the role of international law in restraining military aggression is multifaceted. It serves to define crimes, establish jurisdiction, and provide a legal framework for addressing acts of aggression. However, its effectiveness depends on the willingness of states to adhere to and enforce these laws, the capacity of international bodies to hold perpetrators accountable, and the ability of these bodies to navigate the complex web of international relations and power dynamics.